April 11th, 2017, at Town of Ashland Zoning Board of Appeals meeting. Officially called the meeting to order, which may be the shortest meeting of all time. So as part of any open meeting, a number of things have to happen to allow hearings to open. Butters need to be notified, and then also we need to publish notice in the newspaper. Unfortunately, as Thomas the Tank Engine used to tell my son all the time when he was young, accidents happen and it didn't get posted. So the entire agenda, which was all hearings for the most part, is going to be put off. And so my understanding is that we can't notice in time for the second Tuesday. We'd have to go to the the second Tuesday in May. We don't have time for this month.
Correct.
Okay.
Yeah. And I have a tentative agenda.
Okay.
We potentially have time to notice it May 2nd, for May 2nd.
Yes.
Yeah, but I don't want to duplicate again with
Right.
with the Board of Health.
Yeah.
Oh, right,
Because
right,
it was just,
right.
I expect a crowd.
So we'll
for
keep it on May
both.
9th.
Yeah.
That could be unhealthy.
Yeah. So with that said then, now going through this, the 815 hearing was being withdrawn anyway. So really, it's just 3 hearings. So what do you have for a proposed agenda on the 9th, is it?
Yes, so I can pass this along, if you would, sir. It is pretty much the exact same as today. The only thing is case number 4, which was 23 Washington, that is going to be withdrawn. We do have an application for the Connolly bus parking, and that should be actually in my hands tomorrow.
Okay. So I guess I'm confused why we still have 2 at 7. We can't do 2 hearings at once.
Right.
Yeah.
So that we're not stuck waiting, and the remand is supposed to be scheduled at 7. And we're gonna squeeze that quick one in first, but we can.
The 7 o'clock?
What's the quick one?
The case number 1.
It's
The,
what is it?
The accessory unit?
apartment.
Yeah.
Even those still take us 20 minutes.
Exactly.
Yeah.
So I would do 7 for that, that's fine. Let's do the remand at 7:20.
All right, that's what Josh had it. So, but in the remand decision, it says 7.
In the decision, it also said today.
Right, that's true.
So we're gonna have to go back, someone's got to go back to court
Right.
and get that extended.
Yeah.
So
Adam's working
we'll
on
say
that.
7:20.
Okay.
That's the 40B. I can't imagine that's gonna be super short, but maybe, well,
I mean, I would think there'll be
Be
opportunity
a lot
for
of
public comment,
comment.
and
Yeah, that might
there
take a
may
while.
be some significant discussion by members
So-
of this board.
the second special permit though, case number 3, and obviously we're not allowed to discuss any of these, but might not take too long either. You wanna put that one on for 8:20, give that 20 minutes.
Number 3. Oh, that's the
And if
issue.
we need to open 40B and then immediately continue to later in the evening, we will. And then we'll just essentially have, well, you think Connolly's gonna come in. I don't know if.
Yes.
I don't think we're gonna have time
Yeah, I don't know if
for
that's a great night
a
for
fourth
Connolly.
hearing.
Are we under, is that just been stamped in?
That hasn't been stamped in yet.
Alright, so we're not under, and what is it, variance, special permit?
That is a special permit.
So the clock's ticking, but it's not crucial. So we could do that one, the 4th Tuesday, right? Is that what, does that make sense to the board?
I think so.
And then the last one's gonna get pulled.
Wait, what's the date of the 4th Tuesday?
4th Tuesday. Yeah.
5th of
Third,
May.
May 23rd, right? So
and I won't be here for the 9th.
you won't be here for the 9th, but you're not voting on the 40B, right? It's you, me, and Stu. Okay, so that's fine. And we'll miss you, of course. Text us. Thank you.
I'll be in Milwaukee watching.
Well, don't text me, that doesn't sound. All right.
Red Sox should win that.
So 7 o'clock we'll do as planned. 7:20 then we'll do the pollards. Is that, and then give us enough time after that.
You want to
And
move
then
that one to 7:20?
7:20 and then 7:40 for the 40B in anticipation that that's gonna take a while.
Yeah, in the last one.
Otherwise, we're definitely gonna have to open that 40B and continue it, and that makes no sense.
Can we open Connolly?
We can, if they want to. If they want to waste their time, just come in, open it, and continue.
But you don't want to.
I mean, it's up to the applicant. I mean, we could do them at 7 and then 7:01 do
I mean,
Al's.
if they're gonna have council present, they have to pay for council
Yeah,
to come and open it. It just seems
Yeah.
like perhaps an unnecessary expense
I
to
think
them.
they would want to get that quickly if they can. I mean,
But that's not in yet, so we can't notice that for 2 weeks from now, right?
we cannot.
We
Wait,
can-
what do you mean? Wait,
We can't get that on for the second meeting in this month. There's
No.
not enough time.
No.
for
No.
the 25th?
Yeah,
No.
because you need the 2 weeks. Okay.
Yeah, we need 2+ weeks.
Well,
Yeah,
I
we
think
need
Oh, we
it,
need,
it sounds like the board doesn't want
pretty
to
much we need 3.
bite off all 4. Yeah. Okay. All right, so then Connolly will have to wait.
Till May 23rd.
Unless you tell me there's a really pressing issue on this Connolly application. But that's the bus. I mean, school buses, is that what we're doing?
yeah,
Yeah.
the
Yeah.
bus parking.
All right.
I know they're anxious to go.
Yes.
Everyone's
Yes.
anxious.
Yeah, I
Yeah,
know.
and I get it, but, yeah. Okay, so then it looks like it's 7 o'clock, the Alves, 7:20, Pollards, and
7:20 is the, okay, yeah.
and then 7:40, we'll do the 40B. And if we need to open and continue that 40B, if one of the other ones is running late, we will.
So 23 is going to get pulled anyway. Okay.
Right. Right. That make sense to everyone?
And then schedule it on the 23rd as the first one.
Yeah, Connolly can go first.
Connolly
Next
on the
meeting.
23rd.
You want to say 7:05?
Sure.
And actually, we should probably do 7:05 for Alves, because I think we do have a couple of minutes to do.
Okay.
Is everyone cool with that?
So the 23rd of May, right?
For
No,
Connolly.
Oh, okay.
Yeah,
Yeah, for Connolly, yes.
right,
Everything else on May 9th.
right.
So is there no meeting on the 25th of April?
I don't think we have anything,
We don't have any.
right?
Now, the only thing that we were planning on is if we had to continue 23 Washington. But that is being pulled,
Right. Okay.
so.
Even if it's being pulled, we don't have to do anything with it, right?
But we can't even open it tonight, so it doesn't exist right now. Okay, good, so that's the schedule. If you guys, I'm gonna go coach. But if you guys wanna stay and do your form
We need to sign.
Yeah,
and sign the decision, who's on that one?
Stu, Smitri, and
Or
Well,
not
what-
sign, we need to.
What if there's some discussion about the decision? Can that,
Yeah,
can
we
that be
need-
done?
I mean, the hearing's
the public
closed, but
hearing?
we need to figure out the decision.
yeah, I mean,
Right.
we
That we're at a
only
public
have
meeting, so
an
we
extension
can do it.
until tomorrow.
Yeah, it has to get signed today.
Yeah.
Of the, who are the Stan has resigned, so it's you and me, or the two, remaining full members, or is it?
I'm not a full
No,
member.
Tom is a full
okay.
member.
John,
Oh.
So you are chairing. Congratulations.
I only do the short meetings.
Yeah, well, this one's gonna be short. All right, I'm gonna take my son and get out of here. All right, good, unless, anything else?
the only other thing was I wasn't sure if you had any comments on the new application form.
Well, that's what I was talking about. No, it looked pretty good to me, but
Okay.
the two people who did have comments are here tonight, you know, or
Yeah.
not initially had comments on it.
Yeah.
So I'm sure they're gonna
Yeah.
wanna go through it. And I
Yeah.
have a copy if.
Yeah. I mean, the only,
Yeah.
Stu wanted the case number,
Yeah.
which is on there.
Yeah.
Smirtry wanted some cleanup of the format, which is cleaned up. So
Yeah,
I don't know if you want to call it a staff
Well,
I'm thing
sure-
and-
have you seen it, Yasmin? Yeah. So why don't you guys take a quick look at it, do the decision, make sure everything that you wanted was in there. I mean, it looked fine, but make sure. Yeah.
Okay, so now we'll do the meeting last week, the
The
decision
decision, right?
discussion,
Right.
of which there will be no public input since the hearing is closed.
That's right.
So you
All
can,
right. Good night, guys. I'll
Oh.
see you on.
can we hear me better now? Good, thank you. So I'll repeat that again. What we're going to do is discuss the decision, which was sent out earlier this week. The hearing that happened last week regarding the 23 Washington Street, the zoning board, not the zoning board, the building commissioner's actions, and so forth. I've heard that there is discussion about that. Who would like to jump in first? Stu?
I'll jump in. I had no problem until I got down to the. I,
To get the sound.
I had no problems until I got down to the determination section. And there's a statement in here that says, in the residential B zoning district, the area of the lot is increased by 50% to 30,000 square feet for a two-family structure. Where did that come from and what does that mean?
I will grab the bylaws,
I have a copy.
unless you have a copy.
Was that mentioned at the hearing as a concern?
Yes.
Of whether it
Yeah.
could be a two-family, and so that's one of the, it's in, under the dimensions,
Yes.
under
Yeah,
a note.
Use or,
Looks like my pages fell out.
where is it?
Yeah, it's under the notes. So what it says is for two-family dwelling in the RB district, increase minimum lot area by 50%. So since that was discussed at the
But
meeting,
how did it pertain to the particular case at hand? What, the lot was so small, it never got to 30,000 square feet.
right,
One of the concerns was that you cannot, because it is an undersized lot and you are increasing the use, that you would have to be subject to the increase in required lot size. Yeah.
but if, it's your decision, so if you all want to not include it, that's fine.
Yeah,
Or
yeah, I
reword
mean,
it, that's
yeah.
fine too.
Well, I'm just saying, how could it be made clearer?
Yeah,
In this particular case, this lot's never gonna get there, right?
correct.
Yeah.
So stating it in this fashion,
I agree. Yeah.
what does that do
Yeah.
for us? I mean,
Yeah.
what's the value added?
If you want to say like as dicta or something like of that nature, because I feel like this hearing was the last hearing was very confusing because the petitioners themselves didn't even know what they were coming in for. So I think that needs to be made a little more clear in our determination. Just the fact that we had to keep steering them into, I mean, we were all here, so, the fact that we were talking about the foundation permit and that is it. We were not talking about the special permit, and discussions went on and on about community input and the fact that, okay, it's going from a 1-family to a 2-family, but that had it was not germane to what was being talked about at that particular hearing. So I think that needs to be parsed out some more in our decision. The fact that, you know, there was a lack of clarity on the petitioner's part about what was being talked about. These are the facts that were outlined by the petitioners, but these are the facts that are taken into consideration by the board for this particular hearing. Do we all agree on that?
Not necessarily. I see a house on a lot and a foundation for another building on the same lot. So in my mind, it looks like there's 2 houses on 1 lot.
Mm-hmm.
So that's why I thought that particular statute of increasing by 50% the size of needed to put 2 homes on there came into play.
But there was a new plan for the phase out, right? For the phased planning, and that's why the building commissioner gave the foundation permit for the phased out plan. So yeah, I mean, in the long scheme of things, okay, that could have potentially been the end goal to create this 50% more, but for me, that wasn't clear. I don't know what the end goal for them was. I just saw the phased out construction.
I don't know the end goal. Well, I think I know, but I'm not gonna go there because it's not clear now.
Yeah.
But there's a home and a foundation for the same size or bigger home on the same lot now. So even though it was just a permit for just the foundation, I'm pretty sure they're gonna put a building on it, and now you have 2 buildings on there. So I am kind of jumping ahead a little bit on it. But in order to put a foundation there that's going to be built on, now you have 2 homes on there, you need the extra 50%, which they weren't even really close to the original 20% at 16, which is fine.
Mm-hmm.
But now when you wanna blow it up to
30.
yeah, well,
2-family.
2-family, you know, and you need the 30,000 square foot requirement for that. That's where I just think it's doesn't fit the bill.
Well, what wording would we want to remove that or modify that sentence? Bear in mind, as Phil pointed out, we have until tomorrow to have this completed, so I think we must do it tonight.
Yeah, I mean, if it's a small change, I can, you know, sneak off and print out stuff. I mean,
That's fine, but what are we going to put in there?
Yeah.
Because I think because of the nature of our meeting last week where we were kind of looking ahead to the reality of special permit,
Yeah.
I think that clouded
But that's the issue. When we were determining whether the building inspector or the building commissioner had the prerogative of actually issuing the permit for this foundation.
Right.
And he cited 3.3.5, et cetera, but to really do that, you needed a special permit, and he didn't realize that. That's why I voted to overturn his decision for the foundation. So I don't know how you can put that in this document, because Brian, I think Mr. Forrestal and we voted against it.
Yeah, that's where
Because we realized that, you know, what had happened in all the events that transpired, things were being done, but to actually put a foundation in there, you really needed a special permit. So that was wrong to actually grant the permit for the foundation. That was my thinking when I reviewed the facts, and I think the folks on Washington Street were saying the same thing.
Yeah, I didn't construe the facts that way. I thought 3.3.5 was the first stop. So I don't even think ZBA had jurisdiction to hear that hearing, to be honest. So I wanted to ask town council about that. But because this was about the building commissioner's conduct. So according to 3.3.5, I mean, he had full authority to give the foundation permit. I mean, that's what our zoning code grants him. So the fact that
But-
special permit came into play because of the phase out plan. So
Yeah,
if
the
there
phase
was no
construction plan
Yeah,
if
gave
there
him
was
the
no
authority.
if there was no phase out plan, then I'm totally with you, Stu, that they should have gone through the special permit in order for this whole thing to even start.
I hate to use this word, but certain things have to happen in a rational order. When the building inspector reviews the information coming to him, he's got to determine, does he have all the set of circumstances there? Granted, he has prerogative under section 3.3.5 to do his thing if no other condition trumps that. And
Where
that's
do
the
you-
word I hate to use, but I'll use it. No, he shouldn't have even considered that, because you can't say that you actually needed the special permit to do the work.
Yeah, I'm not seeing that. I'm not seeing anything in our zoning code that specifically says that. So, I mean, for clarity, it probably needs to be a legislative issue for our code to provide some more clarity on that fact that, okay, going forward, this is what the building commissioner should do, and, you know, this is what the special permit will take into consideration, and you can't give the okay for a foundation permit in a phase out to override or to override a special permit if that's your end goal,
Well,
to create a bigger.
it's written right in there.
Yeah, I
The word
think it
special
is.
permit is
Yeah,
right in
I
there.
think it's pretty clear too, in that
Well,
3.3.5.
It says may, doesn't say must. Board of Appeals may, by special permit, allow such reconstruction. So, to me, I mean, I'm for strict reading of the code and
Well,
any laws, so that's
They
just
may,
my,
But
yeah.
they may or they may not. They
Right,
cannot.
yeah.
It's the Board of Appeals.
It's the Board of Appeals prerogative to say that.
To issue
But
the
then
permit or not.
it goes
But
on to
that's-
say that the proposed modification will not be substantially more detrimental than the existing non-conforming structure to the neighborhood. And to go from a, was it 1,200 square foot house to 5,000 square foot?
Yeah, that's a large,
Yeah.
big jump.
You know, I know it got phased down, but that originally is where it started. So 1,200 square feet to 5,000, to me, fits into that substantially more detrimental to the existing non-conforming structure.
I mean, I was not at the hearing, so I'm not going to comment upon any evidence or anything, obviously. But the issue that was brought by the appeal was for the foundation. What may be done with a special permit application, if, as, and when it was filed or not, was not before the board at that time.
Precisely, yeah.
I think we were going there, you know.
I mean, I understand the logical nature of things, because why
jump
do you
there,
put a
yeah.
foundation in the ground if you're not ultimately going to build a building on it? But if I recall reading some of the documentation correctly, the state building code allows an applicant to proceed piecemeal
Yeah.
with the understanding that
Own risk.
it's their
Absolutely, yeah.
their
Yeah.
risk, that ultimately they may not be able to do what their ultimate cause is. So
Oh,
it seems
okay.
like
And I
you're,
think that's why,
like you're,
yeah,
but
exactly.
the discussion is about something that may ultimately come before as a special permit request of the owner. And with that, I'm gonna,
Well, I think that comes back and leaves us to how do we want the determination to read? If you're talking about what's at the bottom of page 2 in the residential B zoning district, and then that continues on to the top of page 3, what do we need to make different that will conform to what we need to put in the determination? Strike that sentence totally, modify it. We have to, or we can't I don't think we can leave it alone.
Well, I think you can say that, it was the intent to have a special permit that, for this residential B, that increased, the lot by 50% to 30,000 square feet, but then justify, or not justify, but maybe put another sentence that, take into consideration that this hearing was solely to address the foundation permit. Because I think that needs to be like the hidden clarity point, even for the public, because, it was extremely confusing at that hearing, and I could see that, public members are frustrated, and it's merited that they would be frustrated because, the whole thing was murky, so our decision needs to be read in a way that, gives clarity to the public and gives clarity to us as a board of how, certain members voted.
And I would think that sentence could be stricken, because I don't think it adds to your decision.
Yeah.
I think your point that putting a point of emphasis in the decision that this only dealt with the building inspector's grant of a foundation would clarify it for the public and for the parties with whatever
Yeah.
they may wish to do by your decision, or our decision, even though I'm not a signatory to it.
So as a point of clarification, in the future, our building commissioner should be very, very careful about granting a permit for a foundation, because it may be okay and it might not be okay, and if it's not okay, then people are gonna suffer financially.
Yeah, if the members of these people that are coming here for a permit to do whatever they want to do, if they know that it's a maybe or maybe not situation, they may think, whoa, wait a minute now, I should not be doing this until all of the other necessary things are there.
But did you guys take into account at all the morphing of the permit, 3 different writings in the
Yeah.
same date? So originally, somebody knew that this was gonna be a giant home, and then it was an addition, and then it was just a foundation. So knowing that he knew that the end game was to do this, I see 2 houses on that lot once that foundation went in.
What's there?
I can't look away and say that I didn't know that was the end game.
I don't see anything wrong legally with the way he proceeded. If our code had said specifically, okay, you can't keep changing the reasons for your foundation permit, or you can't keep changing why this foundation was given, then okay, then you have merit to that claim. But I don't know. I'm not of the thought that, okay, you can read into the fact that no, there should just be one. The permit should have just been granted, and there should have just been one reason, and go forth with that.
Or the permit shouldn't have been granted at all.
Yeah.
But be that as may, we still have to adjudicate on what this decision says. We have to decide what it's going to say.
Right, but aren't we looking back in history and looking at this and saying, was this done correctly?
The decision.
Right.
Yeah, that's what we want, we want the decision to reflect, what you all.
I think we should say also in the decision that, going forward, the board would like to recommend to the building commissioner to take caution before giving a foundation permit, if that's good to you guys.
I don't think that's our
Jurisdiction. I also don't think it's,
Yeah, I don't think we can do that.
I don't think we should advise the building commissioner how to do his job at all. We should deal with matters that come before us. We're a quasi judicial body, and that's what we are here. We're not building experts. Our
That's what my
building
question
commissioner
was,
is a building expert.
I take exception to that because the building commissioner did his thing, and he asked, or it was asked, that that decision come before us. So we were thrust into this whole,
Correct,
Yes.
and then the board makes a decision based on the appeal that's before us. But I think it would be totally improper to suggest in a decision on this matter about what the building commissioner should or should not do, or how he should conduct himself in considering similar matters. I don't think that's our role.
Yeah, it's a town manager's role to
That was
advise.
that was
Yeah.
the point I wanted to bring up, because I
Okay,
honestly
so-
don't think we should
Not
have
our
even
So the
heard
two
them.
dissenting votes plus the one affirmative vote should then be looked at, as you are saying, Brian, by the town manager and
Yeah.
trying to figure out
For
a
next
way
time.
forward for
Right.
the.
I
Yeah.
think that's.
Yeah, I don't think we can cause
Okay,
anything
well,
different to be happening.
does that have to be in the decision in some fashion?
No.
or
I don't believe so.
No, all the decision is saying yes or no or yes.
Okay, so the easiest thing would probably be just to
Strike that sentence.
strike that sentence and then everything else.
So can I bring your attention to the 4th paragraph on page 3?
What does it start with?
Testimony
Yeah,
was
okay.
confusing. I'm hoping that brings in, helps explain a little bit more. And then the second, in that what was before you was the foundation building, the issuance of the foundation building permit. And then the 5th paragraph, the one below it, I propose a little added phrase: the board discussed whether the building permit should have been issued without a special permit and whether the phasing was understood. Even, oh wait a minute,
Well,
that doesn't make sense.
Wait a minute.
Sheila,
Project, yeah?
maybe I would suggest in that paragraph, we consider a phrase to say the property owner has submitted a special permit and also retained a lawyer for,
I don't,
I don't think that's
No,
true.
I don't know if that's
wouldn't
relevant,
go
though.
there.
I wouldn't,
If-
I
yeah.
don't think that's
All right.
relevant at all.
okay?
Can I just remind all of you to be talking into your mic, people who are watching cannot hear you. There's enough so that you can, maybe Sheila, if you had your own, and then shift them around so everyone had their own mic.
Oh, sure. Tom, do you want to grab the one next to you?
Slide everybody down. Where were we?
It's all right, we don't have our own show on WACA, so.
You guys aren't always on TV, so you don't, I
Would break the camera. Go ahead, Sheila.
Well, I guess back up to the testimony one. Does that kind of cover that it was confusing and that the decision before the board was for the issuance of the foundation building permit? Because I understand what you're all saying, and that paragraph is trying to get at that.
Yeah, the second to last paragraph before you get to the decision, where it starts, the board discussed whether the building permit.
Yeah.
I think you should put in building permit for the foundation.
Yes.
Sure. For the
Yep.
foundation.
Yeah,
I agree with
very
that.
good point.
Okay.
That's where I was going. Other changes? Yes, no?
No, I mean, I'm a little iffy on the whole flow of it, but I don't want to like scrap it all. So, I mean, it's all there. So if someone wants to, all the information is there. So if the public wants to understand what's going on, they can. But things could be moved around a bit to make it more clear. But you know what? In the respect of time, I think it's fine.
Let me just raise a technical point perhaps for clarification, and that's on the 4th paragraph where it references that hearing is scheduled for April 11th, 2017. The decision is
yeah.
going to be signed tonight or tomorrow. Should there be a footnote or something, footnote 1 attached, simply saying the hearing was not noticed, so the hearing,
right,
that
right.
hearing did not go forward and will be rescheduled? Or no, we won't,
No,
because we
it's
don't
just,
know.
it's just that the special permit has, but the potential special permit
Withdrawn.
has been withdrawn.
yeah.
But yeah, you guys didn't know that
That's not
then.
been acted upon because
Yeah.
Right.
the original hearing wasn't properly noticed.
Right.
So we should reference in there that somehow, just language that
The lack of proper
the
notice. Yeah.
proper notice was not given and
Yeah.
no hearing was
I could
Conducted.
change it to that hearing is scheduled for a future date, And that would
That sounds fine.
That's good.
to me.
remove all.
I think that would be fine.
Yeah.
Defer to the signatories.
For the signatories,
Yeah.
are there other changes now? Since this document needs to be signed tonight or tomorrow morning, are you going to put together these changes that we've suggested? And
Yeah, I
have
mean,
these
it's
folks
only on
tonight
the-
sign it?
Yeah.
Yeah, I think we're
It's-
going to do it.
Or
You
do you
guys
have
can
a
stick around
blank
for.
signature page?
I have plenty of those.
Yeah.
Could we sign the
Is that okay?
signature page and then,
I don't know if you guys can.
We oftentimes do
We've
that.
often done that.
That's up to, yeah, you all.
If we feel that that's reasonable, then that's a practice which we have consistently over the years.
I don't mind hanging around 10 minutes, 10,
or
15
I
minutes,
can hang,
Josh.
I can also hang
Yeah,
around
I
if you
mean,
can retype.
if
Yeah, I'll hang around.
So the only two changes that we want are adding for the foundation, and the hearing is scheduled for the future.
Yes.
And I was not clear on if we are
Striking
going
this?
to
Striking the in
take out.
residential, yeah.
Okay, you are?
Strike the paragraph at the bottom of page 2, the sentence rather,
Yep, yep.
in the residential zoning district
Yes,
area.
yep.
Strike that.
Okay, and if that's the only three changes,
They're the only 3 changes. Are the signatories okay with that?
Yes.
Yes.
okay.
Thank you.
Yeah, okay, I will take care of this.
Now, moving on, what other things do we wish to discuss that have nothing to do with anything that we can discuss? You know what I mean?
Well, I guess I can bring this up. I was going to bring it up when we were all present, but just access to justice and giving all our town members and citizens, access to legal assistance so that, something like what had happened last week doesn't happen in the future. Because it's frustrating for the public and it's frustrating for us as a board because nobody knows why they're here and we have to keep steering them in the right direction. So I felt like to be productive, we as a board can recommend some legal clinics or some like pro bono services that are available to citizens in Massachusetts to just kind of guide them on what their claims can be potentially and things of that nature if it's okay with you guys.
I think on the surface of things, that sounds like a good idea because as a member of this board for a while, we do frequently have citizens who come forth to us and say, okay, I'm here. And it's not necessarily they're here for the right reason, not citing this one at all, but in previous things, the whole process of getting a special permit, a variance, disagreeing with the building commissioner's decisions. We're not here when those ideas are put forth to them to
Yes.
go appeal your decision to the zoning board. Or as a matter of fact, what happens when we issue an appeal, when we issue a decision, regardless of what the decision is, the people don't know where to go. If they want to appeal it, okay. If they don't want to appeal it, and all of these things that we know, I don't think that people do know. So some kind of assistance, but I don't know if we, the zoning board, have the wherewithal within the town government to do that.
I would suggest it's not our role
I don't think we
whatsoever
can
to do that.
recommend.
We could certainly advise someone that they may wish to seek counsel if they're before us, but as a quasi-judicial body, and I keep coming back to that phrase, but that's what we are. It's our job to deal with the people that come before us and the issues that come before us. It may be that town staff should appropriately suggest or recommend or have a list of people. I take back the word recommend because I don't think anyone in the town should recommend a particular legal entity or whatnot. A reference to seeking counsel or guidance, I think would certainly be appropriate. But again, I think that should be from the town staff level and not from us. We're the deciders. We make the decisions. If you go to court and you're a pro se party, the judge may suggest that you might want to seek counsel, but they're not going to. The judge isn't going to suggest that you go see ABC Legal Services.
I mean, they
So-
do, right? I mean, they have the legal services option, so they're like, okay. I mean, if you go to any court, they're like, all right, you should go to GBLS, or you should go to like some.
We don't have
some
those
sort of-
resources, and I
yeah.
would suggest it's totally not our,
Yeah, I think
totally not our role as the zoning board of appeals to do that.
I think it would be very difficult for us to, suggest go, other than if you have a question about the legality and how to proceed with this, go seek counsel, maybe specializes in zoning and other such matters. And where to find one? Well, I don't think in today's information age, I think they could find one relatively easily. So I don't think it's anything that we can do as a zoning board. I think the
Board of Selectmen or something.
Board of
like that,
Selectmen
yeah.
would be the proper place to propose that. Whether or not they wish to do that is going to be up to them. The Board of Selectmen gets many things. Let's do it this, let's do it that, and whether or not they can actually turn around and do it. Their decision may be the same thing.
Yeah.
Go find a lawyer.
Yeah.
Great for the lawyers.
By the time they get to us, they're already here.
Yeah.
So it has to really happen before they get here.
Well, before, yeah. So, I mean, my foresight was maybe putting like a resource guide under our ZBA page, being like, okay, here are some like legal clinics around the area and some law schools that may be able to help you. I'm not saying that they have capacity to help your case per se, but they'll help to, guide you in a sense that can the ZBA even help address the issue that you have? Or is it a different board that you need to appeal to?
Well, that's part of, I would say it is the applicant's responsibility to apply for the correct relief. Staff helps them,
Right.
guides them, but it all depends on what information they tell us at the time as
So
well.
with that regard, shouldn't we not have heard, like, not going back, but hypothetically speaking, we shouldn't have never have heard the last case?
No, they had every right to appeal
Yeah.
them back. That was the right place to have their issue heard. It was they were appealing the building's inspector's decision.
Which we have done before.
Yeah, that's.
And
that's a-
we've made a decision based upon the.
So we have jurisdiction over the building commissioner's actions? I thought that was.
In that sense, yes.
In that sense, it's
Okay.
a statutory,
Yeah.
yeah.
It's one of our main functions as the zoning board.
Besides
of
special
Should I sign
permits
it,
and
right?
variances, comprehensive permits for 40Bs.
Yeah.
And the actions of the building commissioner, those are the things.
So that's
we
like
have.
read into our.
Yes.
Okay,
Yeah.
okay. Great.
That being said, the Board of Selectmen, I know they have a citizens' participation activity. That would probably be the right time to go and see them.
We need to well advertise that, yes.
So, that being said, do we want to, there is a member of the Board of Selectmen here, I'm sure she could tell you what that goes on, if I'm not putting you on the spot.
Wait, what we didn't comment on?
We'll have to
Just
sign
the
four
the
copies.
Board of Selectmen
Yeah.
being
Is
the
this a
right
good
place to go for
good
the
one?
suggestion
Yes.
about
These are
providing
just to be
a resource for people that
So where
are
do the
confused.
Yeah, I
We're
don't think
getting a
it's-
little far
Yeah, I
far
don't think any
afield
of
here,
that's
aren't we?
any of ours.
Yeah,
Yeah.
Okay.
It'd be nice, but I don't think we
Okay,
can. yeah.
that works for me then. In that case, what else do we have to
Do you
discuss?
wanna-
It's all on my end.
I don't, Mr. Efron would like to
I-
speak.
yeah,
I
I
don't
think
know,
could we-
Mr. Chairman, how you want to handle that.
Mr. Chairman?
Mr.
Yes.
Vice Chairman.
Sure?
Here's black if you want.
Sure.
Were you going to say something?
I had filed on Friday on the 23 Washington Avenue matter, and I know a copy should have been provided to them, is that correct?
Yep.
Of a request to withdraw the special permit pursuant to 4816 without prejudice.
Attorney Efron, I don't mean to interrupt your presentation, but
It's brief, I'll tell.
the legal notice was never published, so you can withdraw it as of right.
Is that your position?
Yes.
Then I consider it withdrawn then, is that correct?
Perfect.
It's on the record, you're on film as doing withdrawing it, so.
Thank you very much.
As I'm reading 48, Section 16, it says, once it's been transmitted to the permit granting authority, It may be withdrawn without prejudice by the petitioner prior to the publication of the notice of a public hearing thereon, and publication has not taken place.
You're correct. When I spoke to the assistant planner this afternoon, I was unaware that notice issues were involved in anything other than the Pollard matter. Now that I'm aware of that all, you are correct, and as usual, you know more than me. Thank you.
That's a first, but I'm going to remember you saying that.
Right.
All right.
Let's go.
Do we have anything further to discuss?
Not that I am aware of. There are
There's a-
four
There's another.
copies. One for,
That's the decision?
yes, for the appeal.
Okay. We don't have to wait for them to sign, so do we have any other issues? Yes, no? Nope. Do I hear a motion to adjourn?
Motion to adjourn.
Second?
All those in favor?
Aye.
Aye.
Thank you. Good night.
Right.